Hello, and welcome to JJ International. My name is Jaime Salazar, licensed U.S. Customs Broker. And today we're diving into a very serious topic that affecting thousands of importers across the United States. Today we're going to talk about forced labor that bans under 19 Code of Federal Regulations 12.42 and the Uyghur Forced Labor Prevention Act, also known as the UFLPA. What the law says, under Title 19 Code of Federal Regulations, Section 1242, U.S. Customs Border Protection (CBP) authorized to detain, exclude, or seize merchandise that is believed to have been mined, produced, or manufactured in whole, in part, by forced labor, including child labor. In addition, under the Uyghur Forced Labor Prevention Act, effective June 21st, 2022, any goods made in whole or in part of a Xinjiang region of China or by certain entities are automatically presumed to be made with forced labor and are banned from entering U.S. unless the importer can rebut that presumption. So they're very strict on forced labor. Why this matters to importers? They may issue a without a hold release order. Your shipment will be detained. You must submit documentation to prove your supply chain is free of forced labor. If you can prove it, the goods will be excluded or seized, and your company could face penalties or loss of import privileges. Okay, so very important to make sure that watch out who you're working with. Industries that are at risk. This affects many industries, especially um, all those industries that are apparel and textiles, solar panels and electronics, automotive parts, seafood and agriculture products. What is it that you must do to comply and protect your company? Map your supply chain completely down to the raw materials. It's very important. Um, and conduct third party audits if possible of your overseas suppliers. Request traceability documents, shipping records, worker contracts, factory inspection reports. Implement an internal forced labor compliance policy and training program, and stay up to date on the entity list and issue that the one that is issued by CBP, Customs and Border Protection. So you better keep an eye out on that. You know, and what is it that what not to do? Don't rely solely on supplier assurances. CBP wants documentation. Don't ignore a detention notice. You have 30 days to act under Title 19 Code of Federal Regulations 1243. Let me give you a little bit of a case study of what really happened. Um, in 2023, a major apparel importer had 2 million in goods detained under the UFLPA. They couldn't prove supply chain integrity, and the shipment was destroyed. This could happen to any company that fails to exercise reasonable care. That is why customs is pretty much telling you that you must be aware of who you're doing business with. And again, it's very important to make sure you have everything documented. And pretty much you have to very well know your suppliers, and use Title 19 Code of Federal Regulations 1242 as your guidance. Assume high risk if you source from in Xinjiang or flag entities. Invest in compliance now to avoid losing your cargo and your reputation, because that's pretty much that stands out between you and anything else. The company's reputation is very important with customs. Um, so if you're an importer, custom broker, or logistics manager, this is your wake up call. CBP is enforcing this very aggressively, and ignorance of the law will not protect you. So be sure to like, subscribe, and share this video. Don't forget to turn on the notification for more in-depth federal law and customs business tutorials. And again, guys, this is I'm Salazar with JJ International, and I want to thank you for watching, and stay compliant, and be aware of the upcoming content that we're going to put out there for you guys. In the meantime, I'll see you in the next episode. Thank you very much.